there's a few choices regarding the type of entity. And there's a corporation, and in the first column you'll see a C corporation, and the third column is an S corporation, and the sole difference between those is how it's taxed, and I'll talk about that in a second. There's a limited liability company, which is the second column, and a sole proprietorship or partnership in the fourth column. Let me rule out the fourth column, which is that the most important reason to form an entity is to limit the liability. So the owner's liability is limited to that which is the assets in the company. A sole proprietorship or partnership doesn't provide that protection. So absent something silly and something really special occasion, I'd recommend that we wouldn't even consider the fourth column. Why I keep it on this chart, I have no idea. But because people sometimes do it, so I want to roll it out. So I just rolled it out. So that leaves us with a corporation or a limited liability company. And the good news is you'll see in the first one, and I should say a corporation, its owners are shareholders, LLC, the owners are members. And the sole difference between a C Corp and an S Corp is the way they're taxed. Otherwise, they're corporations. I'm going to go to the third line in taxation. There is a difference in the way they are taxed. A C corporation is subject to double taxation. And so the corporation pays tax and then the individuals pay tax upon dividends from the corporation. As is contrast with a limited liability company, which you can have taxed as a flow through, which means that the entity does not pay tax, but it flows through to the individuals. And so there's only a single layer of tax. That's a good thing. That's favorable toward the limited liability company. There's also, you can do tax-free merger. Maybe it's just me, but I'm getting some feedback. So maybe some folks want to go on mute. So I don't know if other people are hearing that as well. You can also do tax-free merger. So if you sell it, you can do that in a tax-free way. In a C corporation, you really can't, or an S corporation, you really can't do that in a limited liability company. And but one of the favorable things for a C corporation is you can, in contrast to the double taxation, is you can actually be subject to what's called the 1202 treatment, which is that if you hold on to it for over 5 years and you're in certain kinds of businesses, which you're the outline that you'll be looking at as the exceptions to, you can pay a favorable tax rate. The federal gains rate, and that's actually my favorite rate, which is 0 at the moment. May change, but that's pretty good. And unfortunately, there's a cap on it. I forget what it is. I think it's like $10 million or something, but we'll worry about that later. So, but the point is that you can get favorable tax treatment on the sale of the company if you hold it for more than 5 years and you buy it directly from the company. So that's favorable. So, so there could be, based upon what you're doing, it could be better to be an LLC or an S corporation, or it could be an LLC or a C corp, depends on which one you want, what your plans are. So when you go through the roadmap, you're going to go through some of those considerations for the tax purposes. The second column, which I skipped, was that anybody can own a C corp or a limited liability company. An S corporation has some limitations. An S corporation can basically have individuals own it. You can't have corporations, you can't have joint ventures, you can't have entities. So, for example, to the extent that you're going to have, venture capitalists or other kinds of investors, or even private equity, you can't use an S corporation. So that's pretty limiting. Going to a little further into flexibility and structure. Similarly, that's another anti-S corporation, because S corporations can only have one class of stock. The other entities can have more than one class of stock. So, for example, if you're going to have investors and you want to give them preferences or anything like that, you can't use an S corporation. So, if you're a high growth technology company, you're typically going to rule out an S corporation. We're going to think about the C corp versus limited liability company. If you're going to do an IPO, you got to be a C corp. And similarly, if you're going to get venture capital, you got to be a C corp. They won't put money into limited liability companies. And they're all kind of easy to use. Limited liability companies get a little bit more complicated. I don't think it's dramatic, so I wouldn't make the decision based upon that. But people are accustomed to corporations still. And the most important one is the last line, which is that if when in doubt, it's relatively easy to go from a limited liability company to a C corp. It's very difficult to go from a C corp to a limited liability company because for tax reasons. So if you can't decide and you decide today I want to put off this decision, that's okay. Then you want to start with a limited liability company and then switch to a C corp later. So one of the sets of questions, and I did that really quick, but one of the sets of questions that you're going to go through in your groups is a series of questions that will allow you to come to the conclusion as to, at least in the first instance, which one of these entities we want to be. With your permission, I'm going to stop sharing this screen, and I'm going to go to a different screen.
David, I just have one addition for students that have entrepreneurs or startups that are interested in being a benefit corp or a benefit LLC. I'll work through those, those legal roadmaps with you to go over that, and I'll consult Oded as well, who knows that area. So you still go through the questions, answer it, but if note in your legal roadmap that this is a startup that wants to talk about is interested in somehow building a social impact into their corporate entity, and we'll deal with that separately.
Thank you. Thanks, Stephanie. Any other comments, questions before I move on? So you're going to work through this worksheet and as a group for your specific entity, company. And it's going to start with just a general description of the business. I mean, my sense is that it's always important for the lawyers and the principals to understand the name of the business and what the type of business, et cetera. So that's what this is all about in 2A. And 2B, the reason we're asking these things is these are the exclusions for the 1202 that I just described. So if it's going to be personal service, banking, insurance, you ought to know that the other things identified in question 2B there, then you may decide to be a C corp, but you're not going to get the benefit of the 1202. And then the others are just, again, to give the lawyers some flavor of the business, because it's not in isolation. And when you choose the name of the entity, and number one, you're going to want to pick something that's actually available. So you want to check to see if it's available, and don't forget to check the domain name as well, because it's you may want to keep the domains. You want the name that you can get the domain name as well. Form of entity. There's a series of questions, but I'm going to skip that because we basically just went through those in connection with its form of entity. That's what this is all about. Here are the benefit corporations questions that Stephanie was just referring to. Now let me talk about the founder and employment arrangements. The first thing we wanted to make sure is that the founders are not subject to, I call it founder clearance. Let's make sure that the founders don't have any conflicting obligations, so they're not subject to any non-competes or any non-competes or non-solicits, anything coming out of their former or other current arrangements that would be in conflict with forming this entity. So, for example, when somebody comes to me and they say, "Okay, I'd like to form X, Y, and Z," my first question is, "Well, what are you doing now? Who do you work for? And is there a non-compete or non-solicit or something that you're subject to?" So when you go through it, you're going to go through those questions. And similarly, on the IP, is there any obligation to your current employer or your former employer regarding intellectual property? Is there an intellectual property assignment that you gave your current employer? Or perhaps if you're working for the university, you're subject to the the policy, the university policy in which they own the IP. So let's figure out what the founders own and don't own and what obligations they have. That's the whole purpose of the series of questions in question number one there. Number two is, okay, let's figure out the role going forward. So what title, what role do people want to play? Are they going to be full-time, part-time? What are they going to be? and what role they're going to play. And that's really going to go into a couple different areas. One is that's going to play a role as to how much equity we should get. So we're going to talk a little bit about that in a moment, and the allocation of equity. And we're going to talk about it just as far as what compensation they expect and what restrictions there are. And that goes to item 3 is what compensation do the founders plan to have? That's less about the legal, it's part about the legal roadmap, it's part about just making sure that there's an understanding among the founders as to what is the expectation, what role are they going to play, are they going to get paid, how much are we going to raise? I mean, you may have founders who sometimes are fortunate enough to be in a position that either through family things or other arrangements, they can afford to take a risk for a little while and not receive compensation. Some founders, on the other hand, need the compensation. So let's figure that out up front, and then you can figure out how much capital you need to raise and what arrangements you're going to have with it. We talked about and then the next one is, okay, as we go forward, I talked a little bit about what obligations for non-competes and things the founders are subject to coming in. But let's talk about once they they are involved in the entity. Do we want our founders, and are they willing to be subject to a non-compete or non-compete obligation with respect to the company? I mean, it's not funny to have a co-founder, they quit as a co-founder, and then they start competing with the company. And it's sure as hell difficult to get money into it if that's the case. So let's talk up front about what non-compete obligations people want to talk to, 1, 2, 3 years. What's the scope of that non-compete? What's the breadth? So you folks should talk about that and what you're willing to do. Similarly, are you willing to, on item 5, are you willing to enter into a non-solicit agreement where you agree to not solicit the customers or employees of the company for a period of time? And extremely important is item 6, which is that it's incredibly important that the founders all agree to assign inventions that they have. Both when we form the company, they assign relevant inventions to the company, and importantly, as the company moves forward in their employment or consulting arrangements, they also are and assigning the inventions that they create in the course of performing the services. And it is critical. I mean, it's not funny for one of our founders to own IP and the company be dependent on that. So that's so we want a commitment from the founders that they're willing to do that. Cool. And we talked to founders paid severance if they leave. That's just to make sure that we had an understanding that if somebody quits, they're not expecting severance. That would be an odd provision, frankly, for founders in where you guys are. I'm going to come back to, let me, actually, you will see let's do that more. I'm not going to go through the whole founders pie chart. You can do it, but let me give you the concept. The concept, this is how you divide up the equity among the founders. If there's only one founder, you can go to the next question. But if there's more than one, then you got to figure it out. And let me tell you the way not to do it. The way not to do it is to look around the room and say, okay, how many founders are there? Okay, now we're going to take 100 because I got 100%, and I'm going to divide it by the number of founders, and that's how I divide up the pie. That may end up being how it goes, but that would be purely coincidental. An alternative approach is to figure out what people's contribution is both now and going forward, and then figure out what the appropriate amount of equity to give to them is. And Frank Demler, who's well known to many of us, was kind enough to come up with a system to do that, the pie chart. And I will tell you, it's not perfect, but it does two things. One is it's a framework within which to have the conversation. And it also actually it does a pretty good job comes pretty close to what I think it should be. And what it does is it says, okay, let's figure out what people's contributions are in the 5 areas in paragraph and question 1 there. That's the idea, whose idea this was, what's who's helping to develop the business plan, who has domain expertise going forward, who's taking the commitment or risk. Is somebody actually leaving the university if they're a professor, leaving another employment, going to work for it? and taking the risk associated with jumping to this thing, and who's going to actually have the responsibility for moving it forward. So let's take all 5 of those. Let's weight how much, and to weight 2 things. One is, what is each person's from 1 to 10 their contribution for this. So for example, to the extent that we have a professor who's going to be sort of an advisor, but is not going to have any role going forward, then he's like at a 10 for the idea. He's not really working on the business plan, so he get a 0 for that. Domain expertise, maybe he doesn't know he knows the business, he knows the invention, but not the business, so maybe he gets a 5 for that, right? Commitment to risk, a 1, because he's not leaving the business, but he'll do something going forward. So maybe that's a 1. And responsibility, again, maybe a 0. So I'm gonna end. So we're gonna weight people's contributions on that, and then you're going to figure out, okay, so how much do I value those things? For example, a business plan. I might not weight that too much. I can hire somebody to do a business plan. I mean, it's important, but it may not be as important, for example, as the idea or the commitment of risk. So I may weight the business plan at 2, and I may weight the idea as a 4, and I might weight the commitment of risk as 10. And so you'll weight them, and then as you'll see in the process, then you'll multiply them by together, and then you'll end up with a weight, and then you can weight you can figure out what percentage it really gets. That's the exercise you're going to go through. And what you should come out of that with is a relative allocation of equity among the founders. The next set of questions relates to the vesting of the founders' equity, which is to say, it would be a shame if Oded and I started a new company, and then 6 months into it, I had another opportunity, so I leave, and I own 50% of the company, and Oded is now running the show all by himself. He would be unhappy with me. So what we need is it to vest over time, so that, for example, if I leave after that period of time, some of my stock will not have, most of my stock will have not vested, and I will not own that big slug of that company. So that's vesting over time. And usually vest, I say here in B, 2, 3, 4, or 5 years. I'd lean more on the 4 or 5 years than 2 or 3 on a vest over a longer period of time. This is you'll do the same thing with employees, by the way, for employee vesting. And then you want to think about, okay, so what happens when we sell the company? Well, presumably it'll all accelerate investing because you're all there, but you want to think about that. What happens if somebody resigns and they ought to lose the vesting at that point? Terminate without cause. This is good. What happens if the majority decide, okay, that Mr. X is out? What should happen to his equity, Mr. and Mrs. Equity, and X? And I think the thought is they're presumably still should stop vesting, but that's worth discussing. And terminate with cause. Somebody does something really bad, obviously it should stop vesting. So that's vesting arrangements that you're going to talk about. The next question is one that's sort of an interesting one, which is that if somebody leaves, a founder, should the company have the right to repurchase even the vested stock? So let's suppose that 50% of my stock has vested, 50% has not. The 50% that has not yet vested, I lose that. But what about the 50% that's vested? And it is not uncommon to be able to buy back some of even the vested stock at the then fair market value, so that the founder should get the benefit with respect to the vested stock from the time the value from the time they came in to the time they leave, but not hold on to all that stock going forward. I'll give you an example. If a founder has 50% of the company and 50% of their 50% is vested at the time they leave, then if you don't have this kind of provision, that founder will own 25% of the company. That's not a healthy thing for a company going forward, to have an ex-founder owning 25% of the company. That's not healthy by virtue of being able to attract investment. It's actually not. So you want a right to maybe buy back some portion of that stock. And sometimes I say maybe 50 or 75% of that stock permits them to have some of the stock going forward, but not all of it. So that's the discussion there. You're also going to have a discussion about, okay, so who's going to decide what? Who's going to be on the board? Who's going to decide who's on the board? Are there any decisions that require supermajority? I mean, is it 50%, 75%? Who's going to make the big decisions? Now you want to be careful. I don't want to make, if I got 4 people, I don't want to make sure that I don't want to require unanimous decision, unanimous consent to all kinds of things. So be careful about how far we go. But maybe you do want, more than a majority to make the big decisions. That relates to raising equity, selling the company, et cetera. So that's so who's going to make those big decisions? And the last one in that category is we're going to have stock. Do you want restrictions on the stock, selling the stock? And I assume you do, but that's a question. So for example, again, Oded and I start our company, and I decide to sell all my stock to Jeff, and Oded, while he was happy to go into business with me, not so much with Jeff, and so Lord knows that's true. So so we need some restrictions on the sale of the company, the stock, so the company can either have a right of refusal or you have an absolute right to refuse. But that's the discussion there. The last piece is employee equity, and people like to have equity for employees, and so and while it's beyond the scope of this, I'm a believer that you only give out equity to the extent you need it to attract or maintain employees. So I don't believe in being overly generous with equity. Some people have a different view. We have one client that we're dealing with now that believes every single person should have equity of some sort. It's okay. But you've got to figure out how much you're going to reserve. Just to give you some sense, the one rule of thumb for high growth technology companies is 15% to have an option pool, just to give you some range of it, but that varies. And then, of course, the last question is vesting, which is similar to the discussion we had about the founders, so I won't go into that. So that's that is the roadmap that the checklist you're going to go through in creating the roadmap. And the idea will be that you'll break into the groups. You'll go through these things either now or perhaps even later. In addition, you will create these roadmaps and the legal roadmaps that will, which you'll address a lot of these questions.